Can mental capacity issues render a deed void? This is an interesting one, so interesting I didn't actually know the answer and I had to go and look at it. Well, I'm slightly joking, I knew part of the answer but not all of it. Hi everyone, Simon here from the Contract Company. Contracts is what we do all day every day and sometimes overnight. Lucky us, and it is lucky us, we like it. Righto, so I've had to go and print out some material and referencing some case law that I had to find. So the question that was put to us through our website askacontractlawyer.com is whether mental incapacity on behalf of one person signing a deed can render the deed void. So in this case there was a dispute between an employer and an employee. The employee signed a deed, and then the question that was posed to us is, can the employee's signature on the deed render the deed void if the employee was mentally incapacitated? Right, interesting question. So the answer to the question is simply that yes, mental incapacity can render a deed void, but the real issue is you've got to be able to prove it. So I went and found some case law, and I'm going to have to look at my notes here, of an unfortunate case in New South Wales about a person who was abused or alleged abuse by the church. And they signed a deed, so I won't get into the details obviously of that, but they signed a deed of settlement with the church in receipt, in receipt for some payment. So what that meant was they had a deed of release, they signed up, got some money from the church and walked away. Turns out later they weren't happy with the amount that they were, given under, given's the wrong word, but they weren't happy with the amount that they settled for under the deed of settlement, and they looked to overturn the deed. And so the court was asked to look at whether the person's mental incapacity would overturn the deed, and the answer was, well, yes, it would, if you can prove that the person was mentally incapacitated. And so the court basically said, and I'll just read a bit of this out, that a person will lack the mental capacity to enter into a binding transaction if they are not capable of understanding the general nature of the transaction. So that seems to be the threshold test. Does the person who signed the deed understand the nature of the deed, not necessarily the ins and outs of the deed, but the general transaction that the deed is contemplating? So if the answer to that is they do not understand what they are signing, they do not understand the general nature of the deed, then that potentially renders the deed void. The other issue is, and where am I? I looked at a High Court case of Gibbons and Wright, and that basically said the mental capacity required by the law in respect of any instrument is relative to the particular transaction which is affected by the means of the instrument and may be described. Actually, that wasn't helpful, was it? It wasn't helpful for me and I had to read it. But basically they say that it is also necessary for a transaction entered into by a person without the required capacity to be avoidable that the other party to the transaction have knowledge of the incapacity. So that was the part I didn't realise, is that in my employee versus employer scenario, according to the High Court, they're saying the employer also needs to be aware that in this case the employee had that mental incapacity. And if this person who signs the deed doesn't know what they're doing because and this party, the employer, knew or ought to have known had they undertaken reasonable inquiries, then that will render the deed voidable. But as I said, the whole issue with this, the biggest issue with this whole transaction is the fact that to render the deed unenforceable, you're actually going to have to go to court and get that proved, and that ain't going to be cheap. Anyway, I hope that helps. Sort of helped me. If you have any questions, feel free to get in touch with us, simon@contractcompany.com.au or 1-800-355-455, or please